What is the Battle of the Forms? The Battle of the Forms is a legal concept in contract law that arises when two parties are negotiating a deal, but each side uses its own pre-printed standard contract forms, often purchase orders, invoices, or confirmations, that contain different and sometimes conflicting terms. Instead of sitting down to negotiate every clause, businesses frequently exchange these documents, and a contract may be formed even though the forms do not match perfectly. The battle comes from deciding which terms actually control the agreement. The problem became especially prominent in the 20th century when commerce increasingly relied on standardized forms to speed up transactions. Rather than drafting contracts from scratch, companies developed boilerplate terms that protected their own interests. Buyers, for example, would send purchase orders with favorable terms about warranties and delivery. Sellers would respond with confirmations or invoices containing their own favorable terms, such as limits on liability or disclaimers of warranties. Because performance often began before the parties fully resolved the discrepancies, courts had to determine whose terms prevailed. Under traditional common law, courts applied what was known as the mirror image rule. This rule required that an acceptance must match the offer exactly. If the acceptance contained different or additional terms, it was treated as a counteroffer, not a valid acceptance. In practice, this meant that the last shot rule often applied. Whichever party sent the final form before performance began effectively set the terms of the contract. This rigid approach often led to unfair results because the last party to send paperwork had an advantage, and neither side truly negotiated the disputed terms. To address this problem, modern legal systems, especially in the United States, developed more flexible rules. The Uniform Commercial Code, UCC, which governs sales of goods, introduced Section 2-207, a famous provision that modified the mirror image rule. Under the UCC, a contract can be formed even if the acceptance contains terms different from or additional to those in the offer. Whether those extra terms become part of the contract depends on the circumstances, including whether both parties are merchants, whether the terms materially alter the contract, and whether the offerer objects to them in a reasonable time. For example, imagine a buyer sends a purchase order for 100 widgets, including a clause that the seller must provide a 2-year warranty. The seller responds with an acknowledgement confirming the order, but with its own form that limits any warranty to 30 days. The parties proceed with the transaction, and the widgets are delivered. Later, if a dispute arises about warranty coverage, the court must decide whether the 2-year warranty from the buyer's form or the 30-day warranty from the seller's form governs. Under the UCC, if the conflicting terms materially alter the agreement, courts may apply a knockout rule, which removes both inconsistent terms and replaces them with the default provisions of the UCC. The Battle of the Forms is not unique to American law. Similar issues arise in international commerce, and instruments like the United Nations Convention on Contracts for the International Sale of Goods, CISG, also grapple with mismatched forms. Some jurisdictions adopt variations of the last shot rule, while others apply the knockout rule. The underlying challenge is universal: balancing efficiency in commercial transactions with fairness in resolving unbargained for discrepancies. The doctrine also reveals a tension between legal formalism and commercial reality. Businesses often do not read each other's forms carefully, assuming that standard terms will not matter unless a dispute arises. When disputes do occur, courts must retroactively piece together what the parties intended, often guided by commercial practices and reasonable expectations rather than the strict wording of the forms. A curiosity about the Battle of the Forms is that many large corporations are fully aware of the problem but continue to exchange conflicting forms because it is faster and cheaper than negotiating detailed contracts for every single transaction. They rely on the fact that disputes are rare and that if litigation arises, courts will sort out the conflicting provisions. In effect, the legal system accepts a certain level of ambiguity in favor of commercial efficiency. In conclusion, the Battle of the Forms is a fascinating aspect of contract law that illustrates how legal rules adapt to modern business practices. It shows the shift from rigid common law rules like the mirror image doctrine to more pragmatic approaches under the UCC and international law. At its core, It raises questions about fairness, efficiency, and the role of default legal rules in shaping agreements that parties never fully negotiated. Above, I leave you more videos so you can continue learning law. Remember to give us a like and subscribe.